Here.
Thank you very much. Is there, at this time, is there any public comment?
Wait, 1 second. So for those of you not on the subcommittee, could you please go to the back of the room? Thank you.
Again, this is subcommittee on examinations. If you're not a part of this committee, please go sit.
Oh, sorry. Just have my forgot you were here. I knew it was examinations too. I don't know why. I haven't got my game yet.
All right, is there any public comment at this time? There appearing none. Let's go on to the item A, draft report to the Supreme Court on February 2018 California bar. At this time, I will turn over to Amy Means.
Good morning. Attached to the agenda item was a draft of the report that's going to the Supreme Court. There are a couple of corrections that are going to be made to that report. There's an inclusion from the previous report, the July, that refers to the fact that exam scores that with a score of 0 were included, and that will be omitted, given that we are now applying the qualified taker definition to those exam applicants. Aside from that, does anybody have any comments about the report?
Okay, thank you very much. The proposed motion, is there a motion at this time to adopt the proposed motion with respect to this? So moved by Mayor Kaplan. Is there a second?
Second.
Second by Ms. Brody. All in favor?
Aye.
Any opposition? Motion carries. Let's now go to the second item, 2017-2018 Subcommittee on Examination Goals and Objectives. Have each and every one of you had an opportunity to review the 2017-2018 goals and objectives? I'm not going to take the time to read all of them. Are there any additions or corrections or any additions or corrections to the goals and objectives? If there are none, is there a motion to adopt these examination subcommittee goals?
Second.
So moved and seconded. All in favor?
Aye.
Thank you very much. That now concludes the report from the Subcommittee on Examinations. I will now return the gavel to our chairperson, Ms. Erica Hermanson.
Nice. Score!
No, we're finished.
Are we still hold till
No, we can proceed because it carried over from last night.
Are we going into table B or are we going to proceed with the meeting?
Table B, so let's have a 5-minute break.
Yes.
Oh, yeah. Come on back.
It's Steve.
Yes.
This was,
I think that's the end of all subcommittees, right?
yes, yeah. That was a good subcommittee work, David. I'm very impressed. You've done this.
Short, sweet.
To the point.
Try shorter next time.
We like it. They like it.
Hey, next time, just hide underneath the table. That way you get
Work, right?
Will that be okay?
That's definitely okay under bad good
we are reconvening the Committee of Bar Examiners open meeting from yesterday. And if I could get roll call, please.
David Torres.
Here.
Angelica Hickie. Here. James Bolton.
Here.
Robert Brody.
Here.
Alex Chen.
Present.
James Efti.
Present.
Dolores Heisinger. Here. Karim Kungara. Karen Goodman.
Here.
Larry Kaplan.
Here.
Paul Kramer. Alex Lawrence.
Here.
Esther Lim.
Here.
Bethany Peak. Patricia Villalobos. Here.
Thank you. So we'll start with table B, but before that, Jonathan, I'd like to start.
Yes, thanks, Erica. So I wanted to, this is going to sound odd, I wanted to set the stage a little bit for the conversation that we had yesterday and what we're going to have today. I think because we've been talking in concept with this committee over several meetings about Appendix I, we were remiss in not setting the stage and giving a greater context of what we're doing and why. So I'd like to just take a few minutes to do that right now. As I think everybody here knows, the bar as a whole has been undergoing some massive governance changes in the past couple of years. The size of the Board of Trustees has changed, the structure and roles and number of board committees has changed, and maybe sort of biggest governance change of all has been the deunification of the bar, where we are now primarily a regulatory agency, and the trade associational functions have moved over to California Lawyers Association. So as we are grappling with our new identity as this primarily regulatory agency, one of the things that we are doing is thinking about if we were creating the system today, what would it look like? Right? What roles would be assigned to a committee? What roles would be assigned to staff? How would we sort of define what is the sort of highest level policy decisions and the more administrative decisions? How would we structure this? And so in thinking about that, that's where Table A that we talked about yesterday came from, is what would we have designed? And the questions that we were asking ourselves, would we design a system where we would have a committee of 19 people getting presented to them a report about a cell phone violation? No, we wouldn't. We would ask the committee to develop a policy that tells us that if you bring a cell phone, 0 tolerance, and then staff would administer that policy. Would we design a system where the committee would be having the informal conferences with a small number of applicants? Probably not. What we would want the committee to do is set the policy and the guidelines, help to develop decision matrices so staff could administer that in ensuring the appropriate level of consistency in these reviews of the moral character of these applicants. So none of this was intended as an indictment of any sort on the work that was performed by CBE or any of the committees, because this exercise is going on for quite a number of the sub-entities. It was looked at as how would we design it today? And that's what we were presenting to you yesterday, is our thoughts, our preliminary thoughts on how we would design this system. And that's part of what we're going to be presenting to the board in July and then in written form in September. And what we're also presenting, and I want to be crystal clear about this, I think we were yesterday, but I don't want there to be any confusion. What we will also be presenting is your reactions to those thoughts, because that is a critical piece of the puzzle for the board to know. And so I just wanted to set that stage a little bit, and I apologize for us not doing that yesterday. As I said, I think because we talked about Appendix I in concept a lot, we were remiss in not bringing everybody up to the same page on that piece. And with that, I think we're ready to turn it over to Table B.
Thank you. And before I get to Larry, I wanted to ask if there's any public comment. Yes. Right. Larry.
Two questions. Question one, is the bar still a C3?
I should know the answer to that question, and I do not.
Because, you know, it made sense for it to be a C3 when it had trade association function. The question is, now that it's become basically a regulatory agency, A, should it be a C3 as opposed to being an agency of the government? And B, does that even violate any kind of, if not laws or rule, you know, it may violate sort of the spirit of what it should be.
Well, it's certainly something that we look at.
Second question is, when you started this process, did you look at how the DCA agencies basically run? Because I think they're the closest parallel. Board of Accountancy, Medical Board, Veterinary Medicine Boards, State Contractors Licensing Board, etc., which I think are really parallels to what we're talking about here.
And that is some of the key work that Richard Schaffler was doing, and he apologizes for not being able to be here today. Like all of you, he thought this conversation was going to end yesterday, and so he had to get back to San Francisco. But that is part of the work that he's been doing, is looking at other licensing entities in California, really through DCA, and looking at their structure and their size and how they function and how they use volunteers, as well as looking at other bars across the nation.
I'm sorry, but what is a C3?
501c3.
Nonprofit, private nonprofit, non-governmental organization.
Anything else?
So with that, we're turning over to Table B in Appendix 3, Attachment 3 of the Appendix I document. These are recommendations that are pulled and summarized by from the Walton Parker report. And the first starts with governance recommendations. So we talked a little bit about this yesterday on the size and structure. The recommendation is to reduce the size of the CBE. The next portion related to governance is the to set and enforce 3-year subcommittee chair terms, and to enforce the actual terms rather than continuing past terms of incumbents until replaced. To also develop a CBE skills matrix and apply it to the recruiting efforts. Also to eliminate the CBE subcommittees except moral character subcommittees and examinations. But since this report has been written, I know that we talked about this at the committee level on different ideas. There was a motion that was placed to eliminate the committees. We had a discussion about that and decided against it. And today, on our agenda, Dusty is going to present on an alternative that will achieve what we want to, and also eliminate the redundancy that is seen by having the subcommittee meetings and coming back to the full committee. But for now, I'd like to open it up to see if anybody has comments or questions on these recommendations. Yes.
Yeah, two things. One, a suggestion that it might be better to figure out how we're going to deal with all the stuff that we talked about yesterday before you really focus in on the size of the CBE, because the decisions that stem from, you know, moral character functions, accreditation, et cetera, I think are going to drive the decision in terms of what's the optimal size of the committee. So you may want to park that issue. That's one suggestion. Second suggestion, just a political observation. There are 9 members of this committee that are basically political appointees. Frankly, I don't think the appointing authority is going to be thrilled if they are told that they are going to get fewer. So you need to decide who's going to basically take a hit in terms of that. So those are my own thoughts.
Just a question.
Are we operating right now with less than the 19 members?
Yes, we have 16, so
There are 16 members right now. So there are openings that haven't been filled.
yes.
Whose are they?
We have one attorney position, and actually all three are attorney positions. And with the new legislation that went into effect, one of those is going to be converted to a judicial officer position.
Yeah, so I have a couple of comments about this. I think Larry's absolutely right. We figure out exactly what CB is going to do. I don't think the conclusion we'd have to reduce the size of the CB is in the best interest of governance for admissions. The basis that's stated that a smaller CB will make it easier to convene a simple majority quorum. There's been not one single instance that we've not been able to make a decision because we've lacked a quorum. So this is not a good basis since there's not been a reason to do it. And then the last part that says a smaller CB will be more conducive to member meeting participation. I think yesterday's discussion, just like the discussion we've seen during the course of my 4 years, I will say this, I think the participation this year has been at an all-time high in terms of the number of members speaking up during the committee. It's been true that at times I thought, you know, when I was chair last year that we could have seen more people, but this year has not been true at all. I don't understand set and enforce 3-year subcommittee chair terms. I don't understand what that means. I don't know if anyone wants to be a subcommittee chair for 3 years. If it's the idea that a person that is chair of CB would have to commit to a 3-year term of chairing the committee, I hope that's not the case. I think we would very much eliminate most people's willingness unless they have a great deal of time to participate. And maybe Erica wants to be the permanent leader of the committee. I certainly do not. And then I don't understand what enforced actual terms means. It sounds like there's something derogatory. I'm certainly aware of some committee members serving a long time, but in my opinion, at least what I saw, they were public members. They acquitted themselves very well during their tenure, and we benefited greatly by their historical knowledge and what they brought to the table of having years of experience. And frankly, it's years of experience that we don't currently have at this table, both from a staff point of view and from our committee. So those things I don't understand the basis. I'm absolutely interested in terms of what would be done to develop a CB skills matrix. I tend to agree with let's define what we do and let's let people know what we do, because I think that will better inform people that volunteer to participate or are volunteered to participate what the job is. I think there are people better equipped to do this work than other people. I think some people have like myself, I'm interested in all aspects of the admissions process. Don't know why. There are some people that aren't that interested. And let's figure out who those people are at the application process. And I am interested in seeing what we can do in light of Bagley-Keene in terms of restructuring the subcommittees. I mean, I think that's something we definitely need to look at. And if we can improve efficiency without interfering with public protection, I'm all for that.
I wanted to just add, as far as reducing the size, if we're looking at reducing the number of attorneys, that's not going to go over very well, I don't think, especially when we're looking at admission of attorneys. As far as 3-year subcommittee chairs, I think one of the great things about this committee is that it gives people an opportunity to gain leadership skills, especially our younger attorneys or our newer attorneys. And the vice chair positions give those attorneys a chance to observe more seasoned attorneys in chair positions and learn by example. And if you have people in the chair positions for 3 years and it's only a 4-year term, that really can leave a lot of time for the people who are in those wings to develop and learn and blossom. And really, we're not just here to hear ourselves talk. We also want to develop the new leaders in this profession. So I think that's an important objective as well.
Yes.
Have we ever had a time?
Do you have your microphone?
Sorry.
Has there ever been a time when the chair has been chair for 3 years? I can't remember a time. That's why it was a little bit confusing to me, why that was even there.
That would be a new,
It would be new.
a new thing.
If I may offer my quick observation, this is Procedure Code 6046 that says the examining committee shall be comprised of 19 members. I'm not aware of any statutory interpretation of the word comprising, or should I say interpreting that term with a narrow construction. In other words, when they say shall be comprised of, it means at least 19 members.
Right.
I'm not aware of a single case law that offers the interpretation of less than 19 members. So for one, that is inconsistent with Business Procedure 6046, but also, if you look at Procedure Code 6046, this requirement of having at least 19 members stems from State Bar Act, State Bar Act 24, Section 24. So that means not only is this in conflict with the Business Procedure Code, it is also in conflict with the statute, State Bar Act 24.
Right, this would have to be changed.
And if you look at the statute itself, it says shall be. It's not even open to interpretation. It says 10 of whom shall be members of the State Bar, and also the same for the public members. So something to think about if this is really one of the things that we want to change is this consistent with the legislature and also the statute?
Yeah, so just for clarification, the statutes are noted so that you can see, and it says inconsistent, if there was a decision to recommend a change, the statute would have to be changed. You are completely correct.
Okay. It just wasn't very clear based on recommendation. I mean, we can clearly recommend something, but whether this can actually get the legislature to change it, that's entirely a different issue.
Yeah, absolutely, and that's true with some of the recommendations that the board will see on the CBE, as well as a variety of other sub-entities. There are, in some cases, just state bar rules, in other cases, rules of court or statute, which would need to be changed. Again, this is sort of an exercise for the board to say, what do we think this should look like? Now, once we as a board determine what we think that this should look like, then we would need to convince other people, the legislature and the Supreme Court, to make those amendments to the statutes that might be necessary.
I just want to add quickly, as far as this member meeting participation, as I look around the room, I note that there is not one single member who does not regularly participate in our meetings. And I've been in other committees in State Bar, and that's not the case. There's always somebody who's not regularly participating, and I find that really refreshing. So I also don't think that this issue of more conducive to member meeting participation, I don't think that's a basis either. But there was a hand. Yes, Paul.
Sorry if I'm repeating, but I can't imagine the legislature giving out appointments. Patronage is a word that comes to mind. I don't mean to insult anyone who's here by that.
I'm proud of it.
So it could come out of the lawyer's end, and the Supreme Court's probably not real interested in that either. And also mathematically, I'm not sure reducing the number makes getting a quorum any easier. If you get it too low, then 1 or 2 people having to be absent can prevent you from having a quorum. Whereas if we're talking about 19 people, 1 or 2 or 3 or 4 or 5 still allows us to do business.
I just want to add quickly, as far as this member meeting participation, as I look around the room, I note that there is not one single member who does not regularly participate in our meetings. And I've been in other committees in State Bar, and that's not the case. There's always somebody who's not regularly participating, and
Chair. Yeah, definitely my commentary is on the reducing the size of the CBE. Part of the reason why I'm here is because there is a size limit and there are public members allowed to be on this committee. And so why that's important is because, like I mentioned previously, I come from an area that's underrepresented. The only guy from the Inland Empire. I'm a millennial, just gonna throw it out there. And so, not to offend anyone, but I think my perspective is just different because of that and where I grew up, and because of the area and region that I come from. So I think the size, I think the attorney public recommendation is appropriate, because I'm learning a great deal from the fellow colleagues that are attorneys, but also learning a great deal as well from the other public members. So I think this is appropriate, and I think the current statute reflects a better service to the public.
And yes,
Yeah, also, when you get to size, I mean, this relates again to, are we C3 or even if we're not technically a government agency, somebody could probably make the argument that we are acting, with police powers in the state, because we're deciding who gets to be a lawyer and who doesn't, which is the North Carolina decision.
The Supreme Court makes that decision.
The Supreme Court makes...
The Supreme Court decides who gets to be an attorney and who doesn't.
Right, but we make a recommendation to them.
Yes.
So, but, then you get into the North Carolina situation where the balance between licensees and non-licensees becomes an issue.
and again, the CBE makes the motion to the Supreme Court.
Right.
Anything else?
The next set of recommendations revolve around activities carried out by the CBE. So the first is a recommendation to identify key policy and long-term items to be covered on the agenda that align with the State Bar 5-year strategic plan. The other is to strengthen onboarding practices through mentoring, role play practice, observing or joining moral character reviews. The next item, recommendation, is staff should provide uniform agenda and agenda management process. So I'm going to speak to each of these. I'm just going to go through the list first. The other is to eliminate CBE involvement in formal financial reviews, limit it to approving bar examination fees. So in terms of the first item on the aligning with the 5-year strategic plan, each of the subcommittees now has goals that are established for the year, and that would be one mechanism that this activity could be incorporated into. The other item on strengthening onboarding practices, we've had this discussion with our program managers internally about creating or strengthening our training, CBE training altogether. We already have plans for the October meeting to have to revise our guidelines and the CBE handbook, which currently does not reflect some changes that have occurred. And also that includes strengthening the guideline to be incorporated within that handbook. The other item on the uniform agendas, we've done this. We were required to revise our agenda process that it parallels the Board of Trustees format. So this is something that has already been completed. And in terms of eliminating the CBE involvement, that is something that was also incorporated in Table A as a recommendation. So with that, are there any comments, suggestions, or questions about these recommendations?
I would just note, Karen.
Yeah, I'll start with that. I still don't understand the reason that we're not involved, at least in some basic financial reviews for the admissions division department, and I guess now a program, given the fact that potential licensees pay millions of dollars every year to the state bar for the service of us reviewing the admissions. So I've not understood it. I have acquiesced as a committee member to what I think was a decision made by the executive team last year, in the face of a number of questions that were never answered by the executive team concerning the handling of finances directly related to the admissions fund. But I certainly think that if we are going to do our job as the committee of bar examiners, oversight of the administration of admissions, that items, at least from a big picture view, the budget and how we're performing, should come under our review. And I was shocked to hear yesterday that the plan would be we'd get even less information than we're getting now. So I think that that's the opposite of transparency, the opposite of public protection, and the opposite of being good stewards of a very significant part of the state bar. So those would be my comments.
And I believe we would want to incorporate everything that Karen had said yesterday regarding the budget. Is that correct, Karen?
Yes.
Anything further?
The next item, the law school council should facilitate communications between deans and CBE.
Skip one.
Sorry.
Oh, cooperation.
Oh, sorry, skip one, sorry. Cooperation with the State Bar Board, staff, court, and legislature. So this is, the recommendations include to identify a positive scenario of how the CBE, the California Bar, and the Supreme Court can most effectively work together by using successful cases from experience, as well as developing prospective cases for future guidance. Secondly is to validate the roles and authorities of all respective bodies via the Office of General Counsel review. C, also to educate and inform constituents, including CBE members, trustees, staff, judicial and legislative authorities on respective roles, authorities, and accountabilities. It references the, once decisions have been made, that we would use case scenarios to understand how those roles play out and also those roles pertaining to the CBE, pertaining to the bar, and pertaining to the court. Any thoughts, questions? Yes.
The roles, item B, that seems to me broader than just what the law requires or allows, and there's a lot of policy aspects to that. So just having OGC, who is supposed to focus on just legal analysis and not carrying policy briefs involved in that, seems a little narrow.
I think to a small extent, this was actually referring to that memo that was attached and has already been done. And I think what Donna said yesterday was there's going to be further, or maybe it was Leah, that there's going to be further discussion of what the board is really looking at with regard to the interaction. Am I right with that, Donna?
Yeah, I think this is referring, in fact, entirely to the legal opinion that ODC provided, where we looked at the various roles and responsibilities of the respective entities.
Okay, but again, just as the point that was made earlier about rules can be changed if they serve a good policy, this may be too narrow. It's also bureaucratese, but this thing is, it's like a manual for how to do bureaucratese, documents, so. And that is a complaint. There are various phrases in here. Maybe I'll just say it now because I don't think we're going to have time. What we are skipping through in order to get through this is a discussion of, and Karen alluded to them yesterday, a whole host of assumptions, innuendo, some cases rumor, that are stated as fact, as if everyone knows it and believes it and it's just true. And in the discussion in this document, and from my perspective, it isn't. But I don't think I would become unpopular if we were, as with Karen, if we were to go through this and talk about all those. But I just want to be clear that because we haven't beaten up on every little piece of this, there's much to that I would argue with if I had the time.
Yeah, I think, can I just say this? This is something that kind of bothered me from how we went about it yesterday, and I appreciate Donna's comments this morning to try to set the stage. I continue to have a lot of concerns as to how this is going to be presented to the board in light of what I think is a document that, the Parker Walton report, that does not have much basis in fact. And I don't know how, I know the bar has invested a lot of money in having that done. And when, I don't know how best to right that ship, because my concern is that is going to be something the board is going to read, and without corrections, and they're gonna get this matrix. They're gonna get something that says this is where our committee stands, I don't know in what format, and they're gonna be left of having to make a decision based on what I think is incomplete and erroneous information. So if our interest is to try to, which I think is our commitment as committee members, what can we do to improve admissions, and what can a committee do to be better stewards of that responsibility? It starts off on the wrong foot when we have a document that is set out as the cornerstone of this whole revamping of the governance. And if I had a magic wand, like Donna says, what would we do to go back in time? I would do a mulligan, pardoning my golf expression, with the Parker Walton report. We could internally give a much more accurate presentation of what admissions does and doesn't do than what's reflected in that report. So, like Paul says, we don't have the time to go through it all, but some of these concerns are reflected in this matrix, but the big picture of what we're doing and how we get there and how the board is going to view this is really, for some reason, not being discussed. It's like the elephant in the room for this committee. So those are my concerns. As I said, I echo what Paul says.
Thank you. Anything else? Yes, Angela.
I do want to comment as a public member, when we were given this first stage draft, which I kept from February, I was under the impression that there would be a lot more conversation going on before we kind of ended up with this document. And I don't think it was necessarily a belief that the conversations would be going on with all of us in the CBE, but with the three that were kind of designated to work with Parker Walton. And I guess I'm a little dismayed when I take a look at this original first draft work and I compare it to what is now the final draft, that there is very little change. And so it kind of leads me to believe that whatever discussions were going on for the three, that they were discounted. So I just wanted to say that.
Yeah, with respect to Paul and Karen's comments, Donna's been taking copious notes since yesterday. Perhaps we could have an opportunity to review these notes and incorporate these notes by reference, and perhaps even make some additions and corrections to those notes, and somehow get that to the Board of Trustees, if at all possible, to let them know what our feelings are, to clarify any issues with the Parker Walton report. That's a thought.
Along that same vein, do we want to make sure we've got somebody at the board meeting who can basically speak for us and say, these are things that we don't believe were properly communicated to you?
Absolutely. And also, I would reiterate, so what the report, what the full appendix I report will look like, and I'm from New York, will be the discussion of all of the sub-entities that are being reviewed. And there will be a variety of attachments to that report. One of those attachments will be the Walker-Walton report. But in the report proper that goes to the board, there will be a discussion of, for all of the sub-entities, a variety of topics that will be the same. Size, comparable entities in other states, the division of labor between staff and the committee, opportunities for change, challenges to the existing structure, sort of a variety of things that would be the same for everyone, and then we'll be answering some specific, detailing some specific issues and discussions with regard to each of the committees. And we will be including in that part of the report what the committee's reaction is to any of these recommendations that we are laying out in the report proper. And in addition to us laying out how we've captured what your concerns are, and I have no problem sharing my notes, but they're not well crafted. So I'm happy to share them with you. No question about that. But I don't think that's what should go to the committee. We'll be putting those into full sentences. But you are also free to submit a letter, a memo, whatever format you would like, that we would also include. So in addition to us capturing what we believe your responses are, you can frame your response as well. So there is no concern that we may have misconstrued it in how we would present that. And also being a president of the committee at the board meetings is also wonderful.
When do you anticipate providing something to the board of directors or trustees?
So for the July meeting, there will be a presentation to the programs committee on the CBE review. We'll present them the very documents that we've presented to you, as well as discussing, sort of talking through what some of the discussion was today and yesterday. So we'll tell them, the point is to give them your feedback, so what staff had recommended, and what your feedback was to that. So that'll really be nothing in writing other than what you already have.
And then you have a date and time for that.
So that is July, what is the Thursday, the 19th? 18th or 19th, whatever the Thursday is. Programs committee is usually first thing, so it's usually around 9 a.m. But we'll get a time. We're meeting to set the times for all of the committees next Thursday, so we'll have that time. Then after that, Richard will be putting together the final report, the report proper. And that will be presented to the board at their September meeting, which is September. Amy, do you have that?
I think it might be
And so certainly we're not going to be able to post this report 5 days ahead. I expect it to be fairly large. So it will certainly be before that. But as we complete the CBE section, I have no problem sharing that.
And the September meeting, September 13th and 14th.
Also, can I ask for a quick clarification? So I know these are all recommendations by Walton Parker, but have these recommendations been adopted by the state bar? Because I could see that if they haven't been adopted, there's no reason for us to push forward all of these recommendations when two entities, the state bar and the CBE, have not agreed upon to those recommendations.
Well, there's the staff recommendations in table A.
But I just wasn't certain if these are just still conceptualized recommendations.
Yes,
or
they
they're-
are. Nothing's been.
So nothing's been, okay.
And then those meetings that you referred to, those are going to be open meetings.
Yes, absolutely. And I anticipate, Amy gave you the 2 days, the 13th, 14th of September meeting. As I understand it, this topic will be on the September 13th. The close of this, that's when we do the transition to the new board. 13th is the old board, 14th is the new board.
So in other words, if any of you want to attend that, you're welcome to attend that as well.
Where will they be held? Here or?
Both of those meetings are in Los Angeles.
So, I pulled up the meeting schedule, so the one that's being held July 19th, that's what it says. That meeting is just for a discussion with the programs.
So it's a 2-day meeting of the board, and the way those meetings are structured, the first day are meetings of the board committees, programs committee, the regulation and discipline committee, audit committee, finance and planning. So that's what happens on that first day. And on the second day is a meeting with the full board. The plan for July is that we would present the CBE Appendix I discussion to the programs committee. Richard will be doing a fuller Appendix I discussion to the full board the next day. But because we knew that this would be, that there would be quite a lot of discussion about this topic and a lot of comments, we really wanted to have somebody like the programs committee be able to spend a considerable amount of time talking through this and thinking about it. And so we thought it made more sense for that to go to the programs committee as opposed to the full board, so they can really engage in a significant discussion about it and really understand the presentation, the recommendations, and the results.
Question?
Yes.
So, how is the board working these days? Is it going to be the case that what the programs committee decides is pretty much just taken without a lot of comment or discussion by the full board? Or, in other words, at what point is somebody going to say you're too late with your comments? I guess is what I'm saying, asking.
I think this committee is a fine example of the fact that all comments are welcome. There is no such thing as too late with the comment. The board very much engages in a discussion on items that they feel appropriate after it's gone through the committee. There are quite a number of items that are discussed in committee, and entirely different perspectives are brought up by members on the board who weren't on those committees. This is a significant undertaking for the board and the bar and the entirety of the Appendix I review. I do not expect there to be a single quiet voice in the room.
The next set of recommendations are related to the Law School Council. Specifically, that the Law School Council should facilitate communications between deans and the CDE. Under that, we have work study with deans and Law School Council to design a more robust partnership. Clarify and institutionalize points when the Law School Council and law school deans weigh in at key points, being sensitive to Bagley-Keene. The SPAR and CBE should consider options to gauge interest and opinions early on to build trust and collaboration. Ensure annual admissions day is permanently on the bar calendar. Ascertain the possibility of extending admissions day training to law school constituents and deans. We did this with the Law School Assembly on Thursday. Let's also take advantage of the committee being formed to discuss bar exam review, to engage all deans in the process of overseeing the job analysis, review this work at the planning committee. And this is in the solicitation process for the job analysis. Some of that is already being incorporated. Pending the study about the original reasons for creating both the the Law School Council and RAC, consider combining both into a single organization to broaden perspective and avoid conflict of interest. Now with that, are there any comments, questions?
I gather there was an admissions day this year?
Yes.
Did we send anyone? Did we even know about it? Okay, seems odd. And this committee being formed under D, formed by whom and expected to be composed of who?
So we haven't talked about it, but later I'm going to talk about the job analysis study.
Okay, I can wait till then.
Okay.
Okay. And then finally, I don't personally care, but it may be the case that the Law School Council and RAC, I mean, Law School Council is all the law schools. And I suspect some of the ABA schools may not be that interested in our rules, and so I'm not sure that combining them makes sense for that reason. Whatever the nature of the conflict was, it was not apparent to me from the discussion. So
I would invite any public comment if there is any.
Today you're not a potted plant, right?
Good morning, Greg Bradis, St. Francis School of Law. I would just need to be a resource on how those functions work. I presently am chairing the Leaders Advisory Committee I've attended both of these sets of meetings for a very long time. They are, as you say, two different animals. The Law School Council is statutorily created for the committee to interact with all the law schools in the state. And I think it serves the function of when major things are going to be done, like we're going to change the two-day bar exam. That's the kind of thing that all the law schools really need to know about. We want to have a venue for that. And I think actually the Law School Council came about because at one point a different committee of bar examiners made some radical changes to bar exam, didn't even tell law schools that it was going, and so there was a big drama, and that's how it came into being. Similarly, there was the formation of the RAC came about from the need for there to be interplay on the very specific and detailed rules that we have regarding those state-accredited schools, in which, as you said, Mr. Kramer, the other law schools are not at all interested. The ABA schools really could not care less what the content of those rules are. So this is a body with a very narrow focus, particular to the accredited schools, the collaboration with that provides collaboration with the committee and input from experts, because these are the people who know this stuff, to help you with the formulation of the rules. So that's the distinction between those two bodies. I think they both function really well and have evolved over time to be a venue for ensuring higher quality and public protection and all the rest of the things that are missions in the school. I think they do that very well.
Can I just say something on that? Having participated in both Law School Council and RAC the last couple of years as a representative for the committee, the area that I can think of from a practical point of view that stands out in my mind would be the practical skill courses and the requirements that the Cal schools adopted as part of their curriculum and requirements, that if we know the ABA schools aren't in favor of that, and notwithstanding all our participation in terms of the reform that we worked on under when I was on the board, that if we tried to combine that, it would have been a complete mess. But we were able to do something really proactive that is going to serve the public, the California public, as well as the law students for years down the road. So I think they work separately. I don't think there's anything to say there's a conflict of interest that exists. And I think that this idea of recommending them to be combined, I think reflects perhaps not a full understanding of the separate purposes of both. So if we have RAC, it can deal with our accredited schools, our distance learning schools. We can have the regulations that we are empowered to deal with, and Law School Council can deal on big policy issues. So I think I think it's working right now.
And I believe we also had to rework a lot of the specific rules for the California accredited schools to adjust to changing times and online schools and satellites, campuses, and those are things that certainly ABA schools would not want to sit through. So, and we've relied heavily upon the deans to be drafting that language. That would be probably something we need to keep separate.
I would just add, it's advisory only. Obviously, it can only make a recommendation to the committee or to the staff to support decisions that are made by you. It doesn't make any decisions at all. The RAC, in that sense, is strictly a resource.
Thank you.
Thanks.
Is there anything further from the committee?
All right, the next set of recommendations relate to moral character. These recommendations include to ensure that the moral character review, the process has more specific, clearly articulated standards and guidelines for determinations, document and publish specific guidelines for decisions beyond the existing high-level description, including a waterfall, if-then protocols for decision sequencing, reinforce, extend, and clarify Rule 4. To compare California's guidelines to those used by the NCD guidelines annually. To undertake a review of the reform efforts being developed in other jurisdictions, notably the State Bar of Utah and the Solicitors Regulation Authority in the UK, to determine what possible alternate approaches to reform may be possible, and to retain the CBE level of appeals denied. Are there any thoughts or comments related to these recommendations?
So, I just want, as far as Utah goes, I didn't see any mention of what they were doing. And there is a bit in there on the UK, so it would be useful, I think, to add to the background data. And that's something that might lead us to know why Utah's maybe a model for something.
Exactly. And again, that was listed as a recommendation by the working group, and I have no idea what it is that Utah or the UK does, so.
Maybe David or Larry did it or something.
Yeah, that must be it,
Oh.
right, David? Yeah.
So the other thing I would have, I assume that all of our concerns about who should be involved in informal conferences would carry over, that this idea of D, we're not in favor of just limiting our review. And I don't think we simply want to be at a point, and I guess to speak, I think after listening to the committee, I don't think the committee has any interest in simply rubber stamping the staff's recommendations. And I don't think that's our view. And I would hope that's not what this means in the aggregate. So all of my comments and concerns about, and I think the rest of the committee's concerns about, that we discussed yesterday would be applicable, that we believe that we should be actively engaged in informal conferences. We believe that we should be actively engaged in, is it Rule 6? The Chapter 6 review, and actively engaged on the matters that, as it relates to accommodations that come up, that the staff feels appropriate for us to get input on, and not simply a check off the box. So, and that would continue to say that that would be an important function for this committee to continue to have.
So, in that vein, I have two things I want to mention. One of them is that Karen speaks more than the rest of us, but because the rest of us are quant, doesn't mean we don't agree with her. I mean, she speaks well for us, and we could all raise our hands and say we agree, but just don't think because Karen's the one who speaks, we don't all agree with what she says many times. So more importantly, and this is, I discussed this yesterday, this whole idea of moral character. If you look at our basic job, it is to certify to the California Supreme Court that these people are qualified to be attorneys. And along that vein, we rely on staff to pass the bar exam, to take the rights ruling and those sort of things. But on moral character, that's something that if we just let staff decide the issue of moral character, I think we are basically shirking our duties. That we really have to say, we want to make sure that the standard by which staff raise moral character is correct. Under the current system, most of the marketing staff do a great job, and they pass 90-95% of them. But because we get to do the informal conferences, we get a good idea of where that line is. And if Mark starts sending us, not me personally, but if we start seeing a lot of informal conferences that we think are too far, we're seeing too many people that we shouldn't be seeing, we could say to Mark, hey, many of these people should have been passed without us seeing them. On the other hand, if we aren't seeing enough, we're saying, Mark, why aren't we seeing more of these unlawful practice of law or whatever else? So by allowing us to do the informal conferences, we get to do basically an idea of what we are seeing, what we aren't seeing, and what staff is passing without us having to look at it. Currently, I think the system works great. I think we see a lot of good cases and we make good decisions, most of which we pass to people. But we get to see again where the staff draws that line by doing the informal conferences. If you take that away from us and we only do appeals, we have no idea who staff is passing. We only see people that staff is not passing, and staff may be passing a lot of people that if this committee looked at it, we'd say, no, we don't believe they should have been certified. So I think this is important. Talk too much.
No.
Also, if I may add, I'm just looking through the admissions and education standards under Rule 4.1, and it says Supreme Court exercise inherent jurisdiction, makes sense, but also we're authorized by law to administer the requirements for admission to practice and to certify to the Supreme Court. So on that basis, I absolutely agree with you, because we can't certify people that we don't know who pass through the staff. And then to that extent, I think it is inconsistent, not consistent with Procedure Code 6046 under Section C. So I don't know if this is something that has been considered, but I don't believe this is consistent. If anything, it is inconsistent with the fact that we can't certify these people because we haven't even spoken with them or interviewed with them or conference with them.
So to play devil's advocate on that, you see in the informal conference, I don't know the number, but a very small percentage, staff handle the vast majority that the lower level issues. Mark can certainly explain it better than I, but people be clear without anything. And so I'm not quite certain how that part is different, since for 80, 90, 95% of the folks, you're not actually, the committee isn't actually seeing it.
And that's right. I mean, I don't want to lose sight of the fact that I think Jim also said this, which is the informal conferences are reserved for the most serious cases. And, we do have guidelines, of course, that can be strengthened, standards that can be implemented. I think that's a very good idea that we should do. But you're right, again, this escalating level of review, the majority of the cases are cleared by staff according to the policies that we have and continue to review. And again, the most serious cases are those that percolate up to the committee.
So to that extent, this is not a substance problem because, like you said, if 90% of people have no major issues, there was no reason for us not to certify them. It is the series of those with the serious offenses that we interview and that we conference them in. And so, if you were to take those people away from us and let the staff speak and certify those people, then we can't confirm on our end whether they are actually eligible for admission. So just to answer your question, Donna, it is not that we only look at 10% of the people, it's because 90% of people have no issues.
Or don't have the issues that raise
Or the major
highest
issues
level.
that really raise an alarm or raise a red flag.
Yeah, that's right. They have issues.
Not enough to raise a red flag.
Yes.
Yeah, again, I would recommend that staff look at the disciplinary practices of the DCA. And there are some parallel. There are obviously not a lot of them. There are some things that aren't parallel, but there are some things are. The medical board, the veterinary licensing board, the veterinary board, the board of accountancy, those three in particular, deal with high-level professionals who, are being disciplined, and also the admittance issues. And they have there's a process. There's a whole procedure that you may want to look at. Might be good guidance.
Yes, Angela.
I guess from a practical perspective, I can't imagine how you could make up a decision tree for the level fours for staff. I just can't see it. And so I guess that's why I would not want that to occur. Because I don't think you can create an adequate decision tree that anybody at this table would say, I agree.
Bethany?
So actually, it's kind of along that same point. I'm not opposed to clarifying, the minimum competency definition, because I think that would help benefit all of us, staff or volunteers. But when I see things like the if-then protocols, that's kind of scary to me, because I feel like, considering one of the missions of the state bar is to increase diversity and inclusion, I can't think of a single instance when applying strict checkbox requirements has done anything to improve diversity. Usually we see the opposite effect because a variety of issues, not least of which is just subconscious biases that occur in the review process. And so I feel like if we start trying to have these strict, if this then that, if you have this many DUIs, you've been pulled over for whatever this many times, you're a denial automatically, I think that's going to detrimentally impact the amount of diverse applicants that we end up approving in the long run.
Thank you. Anything else? Yes, Dr. Bolton?
What evidence do we we have, a change needs to be made, and that the proposed change would be better than what we have.
I think Leah spoke to this issue yesterday when she mentioned that the formulation of some of these recommendations are not based on incidents that have occurred here. It's an overall look, and this recommendation is one that, we mentioned this yesterday as well, parallels the process for the appeals, so that what the CBE is functioning as is an appeal body in that process. And so that most of the function would be carried out by staff, and if an appeal, then CBE would get involved in the appeals process. So again, it's not based on something that's not working right now. It's based on aligning with how other functions are carried out.
Functions carried out where?
Here by the CBE. So it parallels like the testing accommodation process.
Oh, okay. And so part of my concern, I guess, in analyzing this report is it seems like there's a quarrel with staff and the CBE. Like, this is me coming in with fresh eyes, and I don't feel that. But this is how I'm receiving it and how I read it when I was reviewing it. And so part of the concern that I have is some of the usurper of duties of the CBE is like for a matter of convenience for staff. And so I feel like in the levels of governance, I think what has been done has been to protect the public. And so for me, I just have issues with trying to strip some of the duties as is, whereas there's no underlying factual basis to do so. It's kind of like last year, you had the Board of Equalization strip of their duties because of a lot of things that occurred. So to have a gut check here at the CBE with no factual basis is kind of alarming, I guess, for me coming in with fresh eyes. But definitely, I hope that CBE members would be removed from this process.
And I think another concern is that the difference between testing accommodations and moral character is testing accommodations, you have professional analysis, you have a professional examination of somebody, either with psychiatric or psychological traits, and we rely heavily on that professional opinion. When you have somebody in moral character who comes in, again, it's like I alluded to yesterday, their candor is a huge issue. Their rehabilitative qualities are a huge issue. And their understanding of what they did is also a huge issue. Whether they are really just taking responsibility for what they did, or whether they're minimizing what they did, that's not something you look at when you're looking at testing accommodations at all. That's not an issue at all. And so it's really not the same comparison. And when you say consistency, again, you can look at two pieces of paper with the same exact instances, and one person can be saying the exact same thing, but if you weren't there at that interview, you don't know the difference between these two people. So you really can't say that it was inconsistent, because one person could be very truthful and the other person could come across as very disingenuous. So there's that anyway. Yes, Larry.
Yeah, the other thing about moral character is it's a very squishy concept. And again, this gets back to, are we a C3, an honorary society, or are we a branch of the state government with the police powers that come with that, okay? And so when you get into something like moral character, it's very subjective. And therefore, we need to be super careful about how we make those decisions, because we're determining the future of people's lives. And I don't have an answer for that, there might be some kind of balance. I recall Bethany's comments made me think of a moral character informal conference. Dr. Bolton might remember, the guy from Nigeria. And staff was ready to deny him. And we felt that there was a cultural, possibly racial bias involved. And so we cleared him. You know, that's the kind of thing that only happens when you've got, quote, a jury of peers, or whatever you want to call it, you know, fellow citizens being part of that process. So it's really careful to maintain that balance.
Just to sum up what Larry says, I think if you look at the whole big picture, consistency is necessary, but the report is flawed to that extent that it doesn't consider inconsistency as being necessary in certain circumstances. And this is the flaw that is rooted in their misunderstanding of how moral character really works.
And I should add one other thing, which is, I think in these kind of instances, again, because of the police power that we basically have, then you always should default to, for lack of a better word, leniency, okay? Because, you know, guilty till proven innocent till proven guilty. But I mean, you know, you always want to default to that, and that's where, you know, a more deliberative process is important.
I'll come on in a sec. I would just add, I think, I could be wrong, but probably the majority of you came because you're interested in moral character, or at least now that you've joined, you're really interested in moral character. And I think that, I said the majority. Okay. And if we took moral character away as one of the responsibilities, it would really take away one of the most interesting aspects of the work of this committee. And I think it might make it more difficult to find people who are interested in volunteering for this committee, and that would be a problem. I would just note that. But Angela.
So I guess I'm that one person in the room that didn't volunteer to be part of this subcommittee of moral character. But I liked what you said, Larry, because for the medical board, I think we stayed away from this conflict by, one, not having any kind of review for moral character for medical schools, even with the applicants when you graduate. It's when you finally get your license that somebody kind of like does a check on you. Now, there are certain medical schools that will do that check as a pre-med student applying, but it's not a rule. I think that overall, they made this decision because really, we want you because you're smart enough to pass the courses, not did you do a felony when you were 12 years old. And so we've left it also up to residencies to decide if you've got something like that in your background, whether or not they want to hire you. So that's how I believe the California Medical Board has dealt with this.
So the next recommendation is related to the accreditation. So the recommendations are a 3-year audit to understand and ensure that CE accreditation practices are consistent with national education accreditation standards, to begin the first audit concurrently with the legislative mandate on accreditation. Before beginning the process, the State Bar should solicit input from the Supreme Court and the legislature, pursue value-driven innovation in education and licensure based on growing knowledge and skill assessment practice. And lastly, accreditation outsourcing should be reviewed seriously considered by the State Bar. So, any comments?
I think we can also incorporate what was said yesterday. Is there any further comment from the public? No. Anything else from the committee?
The last item, the trends in licensing and certification. The recommendation here is that the State Bar should continuously scan for innovations in licensure, certification, and validation. And as Leah mentioned yesterday, the CBE has been identified as the sub-entity to carry that task out. Any comments, questions?
Just the sentiment of yesterday.
Anything else? Thank you, everybody.
Well, one question, generally, sorry, but, so So did we work out how we're going to make sure that our views are adequately represented before the Board of Trustees?
Do we have a motion, perhaps?
Yeah, so I would make the motion that two things happen. I think that the committee, and I would ask them, defer to leadership on how they want it to be physically done. I think a written summary of our concerns needs to be authored by our committee. And then I think that I would prefer to see either Eric or David or Larry, somebody that was on the working group, actually attend both the program committee meeting in July and or the board meeting in September. That would be the motion.
And second.
Do we have any discussion? I would just say I'm more than willing to write something, and if anybody would like to contribute to that or assist in that, Paul, Larry, I would appreciate that, and
I just have a quick question. Considering Bagley Keene, what parameters does the committee have to discuss with more than two persons from the committee? Just so we're not in violation of that either.
So with regard to working together on a memo, if there's less, with regard to working together on the memo, if there's less than the majority of the CBE members working together, then it's not subject to Bagley Keene. But there shouldn't be, mass emails among everybody.
Okay, just making sure we're protected.
No.
But what we could do is we have to write something for July.
we could send a draft.
So then we could put, well, if you send it around to everyone.
Not to
that's-
everybody, not to
right.
everybody, just the people who are.
But then, our next meeting is after that in August, but it's before September, so we could share that letter on the August agenda, and then to the extent it needs fine tuning,
Right.
you can take feedback at that point.
That's a good point. Yeah, that's what we're correct.
So we should put it on the August agenda?
Yes.
So what was that?
So we'll have a draft for the August meeting.
But actually, it will be more than a draft, because it'll be something that we already gave to the
Correct.
program committee. There's no way around, getting total buy-off before the program committee deadline.
And you could update it, the
Right,
draft.
we can update it, so it'll be
Right.
like an interim letter, and then there'll be a final for September.
Yeah, so you may have more anecdotes if you want to pile on and stuff like that.
So do we need a motion to put that on the agenda? Or do you want to?
We still have a motion pending.
Yes. Oh. And it was seconded, and there was some discussion. Is there any further
Well,
discussion?
the friendly amendment would be then to present those ideas at the August 24th meeting.
With the idea of being updated, I'd accept that.
That's correct.
So, just to make sure that timing doesn't get the best of us, what we will do is confirm that, but because the September board meeting comes fairly close to the heels of an August 24th CBE meeting. And so, so certainly what you all can do, because there will be that draft letter that gets submitted to the programs committee, you all can individually respond to Erica, not as a group, but individually respond to Erica with your input on that. If there is, I don't want to get to a point where we talk at the August meeting, a few days are taken to incorporate those edits, and then it isn't part of the package. So that might be the best way to do it, to ensure that everything gets incorporated. And I will do some looking at the timelines, and if there's no danger of that doing it in August, we'll put it at risk of being included in going out with the package when it goes out. Then I will let you know, and you can do it that instant.
So I'll try to get that out as early as I can before that. And I will be able to attend the July 19th and September, is that the 22nd?
It was the 13th.
13th, yes, the September 13th meetings. And if anyone else can go, that would be great too. David. Of course, David might end up having to defend him or something the day before. So.
All in a day's work.
So yes, clarify the motion. a motion again?
Do you want me to do it again? So that we will have, first of all, either our committee chair or somebody she designates attend both the programs committee meeting by the board on July 19th and the board meeting on September 13th. We will, in advance of the program, the next July board meeting, have submitted a letter to the board addressing our concerns with the report and the recommendations. And then we will bring that, our letter back to our committee for review with the idea of having a discussion at our August meeting with the potential of updating it before it's presented to the board. That would be my motion.
Okay, do we have a second?
So moved.
Okay. Any further discussion? All in favor?
Aye.
Any opposed? Any abstaining? And it passes. Thank you, Karen. Okay. So
more?
So we're going to move through very quickly. Moving on.
Go Jets.
Moving on, a report from the interim director.
Yes.
Did we do the minutes?
So we have done Dusty's.
Oh, Justice. Wasn't that
We did Dusty yesterday.
I thought
We did my legal, are you talking about the agenda item?
Yes.
That was closed session.
No, you have the role of subcommittee roles.
Right, okay. You want to do that before,
so that's or 1A4.
Okay, so I'm hoping that you all read this. I would like to credit Paul as being the mastermind behind it. We've had a couple of discussions at other meetings about what are some alternative ways to structure our meetings, given that we are now complying with Bagley-Keene. And I think particularly after the last meeting, interest arose in there's got to be a better way, because the members are required to leave for significant portions of the discussion, and then there's some repetition after decisions, recommendations have been made by subcommittees, which are then brought to the full committee, and then there's some more discussion. So, skipping over to the recommendations, there the page I lost. We have three different recommendations, and then we're going to add a fourth because I was talking to Donna and she had another idea. So first we have the status quo, which is we have our subcommittee meetings, and then that's followed by the full CBE meeting. You're familiar with that, so I'm not going to go through what the pros and cons are. The second suggestion that we had previously discussed was to eliminate subcommittees. The disadvantages with this is that we don't have smaller groups to handle matters that sometimes require some extensive discussions. It eliminates an ability for some leadership opportunities, and it eliminates the ability for members to focus on a particular task or area. We have a rule issue, that is that Chapter 6 notices currently need to go before a subcommittee that's appointed by the CBE and then come forward. And as we have previously discussed, we have the examinations committee that is able to make decisions on examination issues that have to come up because of a pending exam prior to a CBE member. So the new idea is the hybrid, which is we keep the subcommittees, but we don't have subcommittee meetings when they're not necessary. So that would allow the examination, accommodation, appeals meetings to occur in those instances where decisions need to be made on petitions prior to an examination, or also to continue to handle the Chapter 6 violations as we currently have in our rules. However, it would also allow us to, we just meet as a full committee and hear all of the various agenda items. The idea is those people who are on the subcommittees currently would be expected to have a heightened sense of responsibility for those agenda items, help lead in the conversations with some of the detailed areas. But all members would be encouraged and expected to participate in the discussions in both the open and the closed meetings. And the only real disadvantage that we came up with is we don't have the leadership opportunities of having a chair for every subcommittee who's really running those meetings and presenting the information. But now, Donna, I'm going to turn it over to you for option 4.
Yeah, just another thought. I'm not certain if this is any better than anything that's already on here. But the notion that Desi said behind this, the hybrid number 3, is that the subcommittees would exist, but would only meet in those circumstances in between meetings, in between full CBE meetings, and otherwise the work that historically has been done by the subcommittees would be done by the full committee. And what seemed like another alternative to that is, instead of keeping each of the subcommittees to meet each of them in between meetings when necessary, you could also have an executive committee, a CBE, that would serve that purpose for doing the meetings when decisions needed to be made in between meetings on moral character testing, accommodations, etc., and keep the rest of the structure where for the things that didn't need to be done in between meetings, the full committee would vote up, would participate in that, and you could still assign the subject matter experts who would be the people who are responsible for it. That has the same disadvantage that Dusty noted of not creating that leadership track, but it reduces sort of the existence of sort of there being multiple subcommittees for the purposes of meeting between meetings when that could be handled by an executive committee.
But maybe the members of that executive committee could be those future leaders.
Yes, exactly.
Would the subcommittees then meet on different days? They wouldn't meet on the same day that the full committee meets? Is that what you're saying?
Well, the thinking is that you would not be having subcommittee meetings unless there's something that needs to be decided more immediately than whenever the next CBE meeting would be held.
Oh, so they normally would be on the same day?
Yeah,
Unless there's
there just wouldn't even be a separate subcommittee meeting. We wouldn't have a we wouldn't have a subcommittee recommendation to the CBE.
Meaning that the conversation would take place with the full committee.
Okay.
So, think about moral character. So right now, I'm chair, in front of the chair next year, that when moral character has discussions, I, Mark, the other, will talk about certain people that we think the board needs to talk about. So there would still be somebody representative of moral character from the committee who would do that speaking. We might call him a chair, we might call him something else, but that they would still have that job.
Yes. And, you still have moral character informal conferences, and those people who have been on the moral character subcommittee, well, it could go either way. Either those people could continue to be handling the informal conferences, or alternatively, it could open up and more people could be doing the informal conferences. I don't need to be boxing anyone in one way or the other with that. But as you say, being more deeply involved in the details, that's exactly what we would hope those people on that subcommittee would be able to help bring in the conversation.
Any other discussion?
I'm interested to see how ed standards would be dissolved, or how would that work?
So again, the idea is none of the subcommittees are being dissolved. It's just, you wouldn't have a pre-meeting with a recommended action. We would have one agenda, it would be the CBE meeting. It would look very similar to what our current CBE agenda looks like. And when we come to the, Ed Standard matters, everyone would be able to participate in discussion about, whether or not what the investigation showed, whether accreditation should, be withdrawn or, whatever the issue may be. Presumably with the Ed Standard subcommittee members, perhaps being a little more participatory than the rest of the committee.
Or maybe we could walk through, we could walk through a major change request just to see what that would look like.
Yeah, so my concern is we just recently had a very hotly contested major change request, and that subcommittee meeting took quite some time. I think it took us, right, and then the hour took, it took a lot of time. So that could impact other areas of business for this committee. So I'm trying to understand how that's making us more efficient.
So let's think about how, for example, even that case as an example. Currently, we had the subcommittee meet and have a discussion, and the full committee could not participate in that discussion. So, and that was essential to the decision-making process. So we brought it back to the full committee and had some it was the same discussion and some new discussion items too, of the same topic. So under this new model, what would happen is everybody would have the same agenda item, but the discussion that normally was held just with the subcommittee would be held with the entire committee. So there wouldn't be this pre-subcommittee meeting. What you gain from the current model is that some of this has already been, some of the discussion has already been handled. I think issues have been prioritized. So when the full committee comes, sometimes it's a full summary of issues, and so some of that will be, rather than having it addressed by the subcommittee, it'll be handled as a large group. So, but what it does is it reduces a duplication of some of the same conversation happening in the subcommittee from the full committee, happening again at the full committee level.
For a controversial item, could be significant savings in time. For a non-controversial item, you might just save the time of having to make two separate motions, but it's still a little bit. Needs more time for us to talk about big policy issues.
And maybe we could get down to a one-day meeting.
Oh.
The other thing is, Paul had suggested we put this on now before we have some new members who haven't been through the last 6 months that we've all been through together. If it doesn't work, we can make changes again. None of this is ever written in stone. So, I'm just throwing that out there. Maybe we should give it a try and see. And if the functioning you're not comfortable with it, we can always bring it up again on another agenda and try another variation.
So I'm more inclined to go with 3 than 4. So having an executive committee, it puts too much work on too many people, whereas 3 kind of lets each committee deal with their own particular issue. So I would move that we adopt proposed item number 3.
Is there a second?
Second.
Is there further discussion? All in favor?
Aye.
Any opposed? Any abstaining? That passes. Thank you. Now moving on to 0100 is the minutes. Do we have a motion on that?
So moved.
Second.
Any discussion? Any, all in favor?
Aye.
Any opposed? Any abstaining? That passes. 0101. That is, so we're on the interim, or the interim directors.
Yes. So sorry about that. Attached to the report are the key indicators for April and May. One thing I just want to highlight under the key indicators, the registration of general bar examinations. This report was completed or developed for the April and May. I want to give everybody a sense of where we're at with the general bar examination registration. It closed on June 15th, and a total of 9,431 people applied for the upcoming July bar exam. Last year, at the end of, on June 15th in 2017, we had a total of 9,959. So it's a little less, but not significantly. Around 500 people applied less than last year. Okay?
Can I ask another question? So, and I forget the name, there was a new program set up that we would kind of help the student prepare for
Yes.
the exam, and we had to open that up again. How popular was it?
All right, so good question, Jim. So this is the productive mindset intervention. This is, that, again, there was a program that came and presented here in 2017 to the CBE. So the program itself completed registration on June 14th. May 14th, and bar exam results were released on May 18th. So at the time that it closed, we had about, I think, 200 applicants that had opted into that intervention. So when it was realized that there was a peak interest of those people who fell into the repeater category, once results were released on May 18th, we went back to the evaluation team and they resumed registration. So it reopened. What we also did, aside from reopening it, is we also emailed individual applicants that had missed that date, so that at this point, everybody has received a personal invitation to register for, that was in the repeater status, to register for the initiative. Where we ended up in terms of numbers, I think the interest, I don't have the final numbers, but I can have those available for the next meeting, but it didn't bump up significantly.
It did or did not?
It did not.
Yeah, I think the actual, I think Amy was looking at, I feel like there were about 1,500 people initially who had signed up for it.
So 1,500, you're right.
Yeah, as I recall, the researchers were very pleased with the size of the participants, and so that they will have a significant, it's a good enough group that it will be meaningful for their research.
Quick comment. I had seen an actual email that was sent to one of the applicants, and part of my concern is that it didn't even mention what the program is, so there was some ambiguity in what it was actually called. So I don't know if that maybe impacted registration or people taking interest into it, but from my general understanding is this program is a sharing of best practices, right?
It's an engagement through storytelling and creating, some.
I believe in the email it says these stories will help these future test takers as they approach the bar exam. So nowhere in the actual email does it say this is a productive mindset program. So I guess that lack of clarity I think could have been added just to show that this is what the bar is doing. Because for me, I guess from my perspective, it looks like we're just sending them a survey.
So we had a number of back and forth with the people who are conducting the study about the content of the email and what they wanted to convey and what they didn't, because of the way that they were doing the study was it was important to not say, here is exactly what we're doing and here's what we expect you will get out of this. It's part of the study tool, and so because I had actually done some initial edits where I was suggesting a lot greater specificity, and it was explained to me why they didn't think that was appropriate in order to enable them to effectively do the study.
Okay.
How many people were it sent to?
I don't have the final number, so
About
when it
1,500.
closed 1,500,
Sorry.
but then we reopened it again, so I don't have the actual final number.
Everybody who applied for the bar, when they submitted their application, that came up and invited them to do that, and then we sent 3 subsequent emails before the initial May 11 cutoff date that said, hey, there's this thing, and you haven't signed up for it. Are you interested in that? And then when we reopened it, we sent emails to everybody who had applied in that time since it had been shut down, and everybody else who was applying afterwards.
Does it cost? I mean, is there a cost for it? Thank you.
So, Chair, if I may. So I guess for me, the Thought Productive Mindset Intervention Program, I guess for me, that comes up something differently than as what was presented to the applicants. So I guess in the future, we could be a little more intentional with our outreach and our practices. Because productive mindset, I guess, sounds like some ways to be more productive, to use some mental exercises, whereas a sharing of stories is kind of different, I guess, from my perspective. And so I just want to make sure that's reflected. So thank you.
Okay. All right, so the next item, so we finished the key indicators, an update on the AIMS project. So again, this is the Admissions Information Management System. Where we're at now is our vendor Slalom has completed its discovery period. Oh, sorry, did I miss that? Yes, sorry. Attached to the agenda is the proposed schedule for the October 23rd meeting in San Francisco.
It's August 24th.
Okay, sorry about that. So attached is the upcoming agenda.
But we'll have to change it now that we have the last motion.
Yes, it will get revised.
And are we only meeting on Friday?
Yes, Saturday we have a calibration meeting.
Oh.
All right, sorry about that.
Quick question, does that change the start time of our committee meeting? If the subcommittees are just wiped out? Or the ones that aren't necessary are wiped out?
So we would start the full meeting at 9 o'clock.
Right, we'll start in the morning. It'll probably take about the same amount of time because we're still doing all the things the subcommittees did. We're just doing it once in a general meeting instead of at the end repeating everything.
So we'll start the general meeting at 9 o'clock.
Okay.
Okay. All right, the next item is the AIMS to update. So I talked about the Admissions Information Management System. We completed our discovery period. All right. Let me take 2 or 3. Sorry about that. All right. So the bar exam. The July bar exam is coming up, and any interested CBE members could contact us. I know this has come up before. We either send badges to everyone, and there's 2 options on the table right now. To send a badge to everybody who'd be interested in coming to visit the July bar exam sites. There are a total of 16 sites around the state. And the other option that we can also explore is just contacting Kim or I if anybody's interested in getting the badges.
And did you have a deadline of sending people to contact?
As soon as possible, please. Because I'm getting ready to prepare for July bar exam.
Yes, thank you. Just wondering, which is less work? Send them all out at one time, or, for getting phone calls or emails individually?
I don't mind, just to let me know, but it's up to Amy or...
Well, we tried one cycle of having everybody contact us to get a badge, and I just wanted to get a sense of how that worked for the committee members. Do people have a preference? Would you rather everybody just get a badge for the July bar exam, or was it better to inform us and we send it out to you?
I'm gonna just get it.
It just kind of puts the onus on her, like, did I send that one, did I not?
Yes,
sure she doesn't, if she has, has to do it all at once, it's not, it just seems less cumbersome.
So is that the group's preference to have one bulk mailing of badges to all members?
Can we get a show of hands who would like them all sent at once? It
Well-
looks like that's the majority.
Okay. And Robbie, did you have a question?
Well, I was gonna say maybe you could ask everyone now, we're all here, who wants what, and
Okay.
by way,
But
Kim
it
is
sounds-
sitting right
yeah.
there.
But it sounds like the majority would rather everybody get, receive a badge for the July bar exam. Okay, we'll do that. Thank you.
Thank you. All right, now.
Yes, since I seem to be really excited about this topic. Okay, so as I mentioned, we completed our discovery period. This is a 10-week period where we spent time with our vendor. They came to our offices and worked with teams, units, and individuals on how we carry out our functions in the Office of Admissions. In the end, this discovery period yielded 680 user stories, and that is a complete understanding of story is a mirror of description of what people do as they carry out their function. So user story could be something like, I am responsible for creating badges for the July bar exam, as an example. So for the Office of Admissions, 680 stories were compiled, and the idea now is to design and build around these stories. Our goal is the vendor has 24 weeks to finish build, and our current target launch date is November of 2018. Okay, great. The next item is a job analysis update. We talked about this at the RAC meeting. Where we're at now since the last meeting is an RFI was completed, and at the end of that RFI period, 3 vendors submitted responses. That has led us to now using based on information from those responses, we gathered ideas, and we are now moving into a solicitation process. Access Lex, we reached out and applied for a funding opportunity that has been granted. So Access Lex will be providing funding for the job analysis in California. We're also in the process of soliciting for working group members. So working with the current bar exam working group, we formulated an idea of the composition of what that working group will look like. Again, this is a working group strictly for the job analysis task. That group, we're seeking nominations for entities and stakeholders in these areas. Attorneys from small, medium, and large firms, bench officers, public sector nonprofit attorneys, law schools, the State Board of Trustees, labor economist, CBE, Senate and Assembly Judiciary Committee, the California Supreme Court, ABA, National Conference of Bar Examiners. We'll also have probably a member of the Access Lex team as staff members as well. So the process where it stands now is we are preparing the forms for to be circulated and appearing on our website, and also that the decision is going to be made, the selection process is going to be carried out by the Supreme Court. And once we have our committee, and once we have our vendor, in terms of a schedule of when this study will be completed, it is approximately 18 months once a vendor has been selected. Any questions, thoughts around that? Okay. The last item. Oh.
I do. I don't know if it's appropriate to mention at this time because it's sort of associated with one of the footnotes that I see in the examination report that I wanted to bring up under page 28 of the recommendation report. It reads, and maybe this is of interest to all the CBE members, it says some CBE members argue that the full CBE should have had a chance to review the vendor offers and offer opinions on the choice. Such a role seems well beyond CBE accountability or knowledge domain. More appropriately, perhaps, when institutional changes may affect the CBE's work, the CBE should have an opportunity to request or specify functionalities needed in the system, but not take part in the process of vendor selection. I don't know if this is something that that is coming from the staff directly, but if I recall from our several meetings ago, I think it was a collective decision to have at least one person from the committee to represent the CBE at the vendor selection meeting. And now this footnote seems to say that we don't have the knowledge domain and that we should not be participating in such a process. Can you explain to me how that sort of, my understanding is this is something that was recommended by the staff as well, that we should have someone represented at the meeting. So can you sort of share your opinion about this footnote and why it is what it is?
Where the footnote is appearing where?
On page 28 under footnote 64.
Of the
Walton Parker report.
So on page 28.
It basically says this is well beyond CBE accountability and knowledge domain. So not only is this footnote inconsistent with the CBE collective decision, but I think it is also inconsistent with the staff recommendation to have someone represented at the meeting.
So this is part of the analysis of what are the appropriate policy decisions for the CBE to participate in versus the more day-to-day operational administrative decisions for the staff. That analysis goes along with those questions so it's not examining whether or not it was inappropriate. CBE made a decision, staff made a decision, I wasn't in the room, I have every reason to believe that's exactly what happened, that said that there should be a representative. We're, again, sort of looking at what, if we were designing a CBE today, what would we say should happen, what role should they play, what role should they not play? And so that's where the recommendation of the consultants came down that said, yeah, participating in the selection of a vendor is not that's an operational day-to-day, that doesn't make sense for the committee to be part of. That's where that comes from.
I appreciate the comments. I just don't agree necessarily about this outside of our domain expertise when I'm sure some of us here actually even have a master's in electrical engineering. We actually know the vendors just as well as anyone within the staff member team who's tasked to look at these vendors. What I'm saying is, it just seems inconsistent to me that you have a footnote hidden somewhere saying this is outside our domain expertise when the committee and the staff have agreed in advance about us being represented at the meeting. So that's all I wanted to put that out there. If this is about administrative convenience, about making sure that this is within the scope of responsibility, I understand that. But this footnote goes well beyond that. That's touching upon our domain expertise, our knowledge domain. This is something that we need to make sure that this is reflected.
Alice, you wouldn't happen to have a master's in electrical engineering.
Beg pardon?
You wouldn't happen to have a master's in electrical engineering, would you?
Oh yeah, I actually do. Sorry, I should mention that. Yeah, and I'm also a startup founder of 2 companies, so I'm well aware of Salesforce and a lot of software companies in the industry.
Oh, okay.
But it sounds like it says it's outside my knowledge domain, so I just wanted to make sure. Thank you.
Okay. The next update is from Donna, and it's related to the fee bill.
I feel like I've been talking quite a lot today. I will try and keep this short. So I just wanted to give you an update on Assembly Bill 3249, which is the annual licensing fee bill that's proceeding nicely through the legislature. The bill is scheduled to be heard in the Senate Judiciary Committee next Tuesday, June the 26th. And I wanted to highlight for you a couple of items that are in the bill. One of the reasons I wanted to highlight them is because the bill is 70-plus pages long. And so it may not be easy to pull out the items that are of importance to you, and so I wanted to bring them to your attention. I also want to alert you that one of the reasons that it's so long, and one of the reasons why, if you were to catalog all of the sections of the Business and Professions Code that impact admissions or the committee, you might see a number of these sections reflected in the bill, is because as part of the split of the sections, and the split between the regulatory functions and the trade associational functions of the bar, we are changing some of our nomenclature. And so we are no longer talking about members of the bar who pay dues. That is more of a trade associational thing. So we talk now instead in the regulatory function of licensees who pay fees. And so therefore all of the sections, or as many as we caught, that mention members or mention dues have an amendment in them that is changing that to licensee or fee. And so you may see a number of CBE related or admissions related sections that appear to be being amended, and for most of them, that is the reason that they're being amended. So I just want to alert you to that, and then I will talk about the ones that are being amended substantively, as well as a couple of others. First, government code. Business and Professions Code 6060.3 is being amended pursuant to a recommendation of the CBE, which was brought to the Board of Trustees this past November, to move forward by 15 days the final last deadline to apply for the bar exam. So right now, applying for the February bar exam, the initial deadline is November 1. If you apply by November 30, you have to pay $50. If you apply anywhere between November 30 and up to as late as January 15, you pay $250 for that final last deadline. What the committee proposed and what is in this legislation is moving that last date from January 15 to January 1 for, among other reasons, but the primary reason was to give those folks who are applying on the last day and who are also petitioning for a testing accommodation the ability to have that testing accommodation reviewed appropriately and appealed if necessary within the timeline. If they are petitioning for that on the last day of applying on January the 15th, you don't have the full 60 days that we tell people it really takes to go through the process. And so that is why, as I understand it, you all initially recommended that, and that's why that is currently in the bill, so we have every reason to believe that will be enacted. Another item in the bill substantively dealing with the Committee of Bar Examiners was an amendment to Business and Professions Code 6046.5. And all that is doing is with regard to the Senate, Assembly, and Governor's appointments to the committee. The current language of the statute talks about the term starting at the annual meeting. We no longer have an annual meeting. And so to reflect that truth and also to provide greater flexibility for those appointments, that line is just stripped out. And so there is no presumed start date for the term. That amendment was put in by the legislature. They wanted to create that flexibility that they could make the appointments whenever they needed to, whenever they were able to do that. And then a couple of other things that I just wanted to mention briefly that I thought would be of interest has to do with the Lawyer Assistance Program. As you all know, this past January, statute and rule were made clear that the Lawyer Assistance Program applies not just to existing lawyers or former lawyers, but also to law students. It had previously been available to applicants for the bar, but not to law students. So, but there are a couple of pieces that still needed to be changed. The Lawyers Assistance Program offers a financial assistance program that is currently offered through a loan to those people who don't have the ability to pay. And it is a loan that can be as much as covering the first year of the group facilitator cost to participate in the group sessions, as well as the lab testing costs for people who have urine testing requirements that are part of that. The rules specifically said that that financial assistance program is open only to active licensees and former licensees. That piece is being changed to provide that anybody who's eligible for LAP, which would include law students and applicants for the bar, would also be eligible for that financial assistance. As we know, often those are folks who need it as much, if not more, than anybody else, so it would open it up for them. Also, importantly, the statute currently prohibits the use of lawyer assistance program funds for treatment and recovery services, which is why we've limited that financial assistance just to group facilitator costs and lab testing. There is an amendment that is in this annual fee legislation that would specifically allow the lawyer assistance program funds to be used for treatment and recovery, again, for all LAP participants. So once that gets enacted, we'll need to revise the financial assistance program rules, which are set forth in the state bar rules, to make clear what, in addition to urine testing and group facilitator fees, would be covered. But I just want to let you know that we're expanding the ability to help cover costs for the participants in the lawyer assistance program.
Okay, great. So if we could go to subcommittee on examinations. Open.
Thank you very much. The subcommittee on examination unanimously voted to finalize the draft Supreme Court report on February 2018, California bar examinations, to the Supreme Court.
Question.
Yes.
There's a sentence in there that says a member of the EDGE team and members of the Committee of Bar Examiners supervised each group of graders. I felt like I was a guest at the calibration meetings. I don't want to take credit for supervising them, so I wonder if we want to modify that sentence. Maybe just say the EDGE team supervised them.
Where is that?
It's on page 2 of the report.
What paragraph?
Actually, I just copied it in my notes. I think near the top. Yeah, the first full paragraph.
I got it.
If we could amend that.
Yes, we can do that.
So if we have a motion,
And with that correction made by member Paul Kramer, move that the draft Supreme Court report on the February 2018 California bar examination be finalized and submitted to the court.
I'll second.
all in favor, or any discussion? All in favor? Aye. Any opposed? Any abstaining?
Finally, the committee moves to adopt the 2017-2018 goals of the examination subcommittee.
There's a second.
I'll second.
Any discussion? All in favor? Aye. Opposed? Any abstaining? That passes. Okay, on to operations and management.
Thank you very much. So we got 3 items on the open calendar. The first is 0300, the February 2018 California Bar Examination Cost Analysis. That was presented by Tammy Campbell, and we would move that report on cost be received and filed by the committee.
Second?
Second.
Any discussion? All in favor? Aye. Any opposed? Any abstaining? Any passes.
Thank you. The second one does not require a motion. It's the financial analysis report as of March 31st, 2018. It's attachment 301. We don't require an action on that.
Thank you. Any discussion on that? Okay.
And then the third one was a review of our subcommittee on operation and management goals. And in the interest of the hour, I'm not going to belabor the point, but on our goals for this year, and we were supposed to cover today, this week and today, was the subject of minimum competence. And I would be remiss if I did not bring up to the committee's attention that in spite of this being on our review, our goals, in spite of the fact that we are a policy setting committee, that this was taken away from us by an email that I received before this committee. So if you, as a reminder on this, it's still on the goals. I think it's in the interest of time. I don't think it's an appropriate matter to belabor today. It's something I would like to have brought back to our committee as a whole for August and on a go-forward basis. I do think the subject of the definition of minimum competence remains within our body of work. I understand there's some belief that this working group is going to address it in some time frame of which we do not know when that will occur. But you'll note even in the Parker-Walton report, there is a criticism that we've not defined minimum competence. So as I said, I don't think it warrants a discussion now. The goals are what they are. Other than that, we've been doing a great job. We don't need a motion on it. I conclude on that.
Thank you. Can I respond to that? So in terms of the definition of minimum competence, I just want to highlight that we are planning on doing that when the data from the job analysis comes back. That we want data to help define and be part of the review and redefinition of the minimum competence definition. So just it's going to come back to the CBE as part of the discussion and one of the outputs of the job analysis report.
Is that it, Karen?
That's all I'm going to say on the subject right now.
Thank you.
Should come back in August.
All right, thank you. Ed Standards.
Okay, so we have a number, about 7 items here, not all of them requiring a vote, but the first one, Macmillan Academy of Law, this is a school that had been out of compliance for a number of years, and there have been some inspection reports that were conducted over that 10-11 period, and there was even a 5-year period where the school didn't have any students or faculty, just basically not in operation. There was basically the committee voted that the school, we recommend that there be a withdrawal of registration. Any discussion, questions for the committee?
Yes. Decertify, is that withdrawal of registration?
Ultimately, yeah.
Your mic
It's like
when
the
you
first step.
Any other questions? So we have to put this to a vote, right?
So
Yeah.
there was a motion, is there a second?
Second. All those in favor?
All those in favor? Any opposed? Any abstentions? Okay, so that passes.
So the second one, Lady Justice Law School, it was a major change request to do a relocation of the law school. One of their reasons, they had 3, primarily cost, the timing that their existing lease was up, and as of June, or will be up as of June 30th, and they have the means to, and they have a site designated to make the move, just seeking request or approval from the committee. Discussion.
First, there is a motion.
So moved.
Second, and discussion? All in favor? Any opposed? Any abstaining?
The next, California Desert Trial Academy College of Law had submitted a progress report on its hybrid JD program, and the motion at the time that what committee was comfortable with what they as well. I should say it was a little bit of a light report. We did have some discussion on getting some additional information as well as a follow-up inspection to really see what the program, what it looks like. The motion that the committee discussed as receiving the report, and finally, to the satisfaction of the committee, within 60 days at the end of the first year of the law school, prepare and submit another report to the group.
So, motion. Second?
Second.
All in favor?
Aye.
Any opposed? Any abstaining? Okay, that passes.
So this one doesn't necessarily need a vote, but there was a notice of change in law school administration of 3 different schools. The schools were up here. Empire College School of Law, the San Francisco Law School, as well as the California Southern University School of Law. So some administrators are retiring, and all of them except for one was would let the committee know as soon as possible as that group or as that individual was identified.
Thank you. 0404.
404 is the Lincoln Law School of San Jose had a major change request. This one was an acquiescence of a number of different joint degrees in MLS, joint MLS JD, and an LLM degree as well. The motion for the group that we discussed and agreed upon was, sorry, I'm pulling it up here. Recommend that the committee approve the 3 major change requests and provide the acquiescence to allow the law school to offer and start teaching those degrees effective with the fall semester of 2018.
So moved.
Second.
Is there any discussion? All in favor?
Aye.
Any opposed? Any abstaining?
The 6th was our subcommittee goals. Again, there was a discussion, but there was no edit or modification to the goals that we had in place.
Thank you. And then Natalie, sorry, not Leonard, or report on the rule and guideline amendments.
So just to quickly summarize, the committee is well aware we've been working since 2013 on a package of rules with 2 elements. The first element is one that is ongoing, that is considering whether there should be a mandatory path to accreditation for the unaccredited schools. Should that continue, that will require changes from both the court and the legislature that are not pending at this time. The other portion of that same study package involves a brand new option that would allow the registered unaccredited schools that are fully online to pursue Cal accreditation for the first time. Those rules were created as a result of the 2 working groups sent out for public comment, approved in principle by this body, as well as the Board of Trustees. So we are separating those 2 initiatives that previously were joined with the idea that the committee could move forward with the online portion, accrediting those fully online schools, and it is believed there's a lot of interest from those schools to pursue the Cal accreditation when it becomes possible. So at the August meeting, we intend to bring you just those isolated rules, simply in the form that you've already approved them in principle, plus the attendant forms, timing, etc., so that you can decide whether you think that's ready to present to the Board of Trustees and release, most likely in the fall, to the schools to begin those applications. So a fall application would be unlikely to be receiving approval for this school year, but would get the process going for a future year. And just for context, the ABA allows 15 credits, considering moving up to 30 at a discussion this August. California would be doing something very novel for the first time, allowing a fully online school to pursue accreditation here in California. Many other types of programs do that. It will be the first time in law should the committee proceed with this project.
Moral Director?
So with respect to 2017-2018 proposed goals, I would point out the plan is at the August meeting to have a presentation by the Office of Chief Trial Counsel on its role in moral character determination for the State Bar Court, and among other things, discuss how we, in our informal conferences, can create a better record for that. So that will be an interesting discussion in August. And then Mark is also working on some practice of law information for the local the moral character committee to work on. Hope to have that to the committee next meeting, and then I'll let you do the oral report on it.
Did you want to cover the OPEC number, just to cover it for the record? The goals.
You want me to go over the goals?
No, just.
I think we just talked about it.
Okay.
Yes.
So there's the minutes.
Yes.
Thank you.
With respect to the, this was an oral report to the subcommittee on an agenda item before the Board of Trustees with regard to a change to the State Bar Rules of Procedure, Section 2302, that that has some impact on moral character proceedings, in that it allows a very limited disclosure in third-party subpoena declarations regarding the nature of two trial counsel proceedings in moral character, as well as confidential investigations. And in fact, the rule change in Rule 2302 is no more than a codification of current practice. I can go more into it. I can explain it more if you'd like. But I gave a report earlier.
Were there any questions about the report?
Thank you.
Do we have a motion, or is there anything?
Is it closed?
We did all of those.
We did the meetings.
Oh, let's see.
Meeting minutes.
We didn't do the
I don't think we did the
minutes.
meeting
We
minutes.
didn't do the minutes.
And I'm not sure we did the subcommittee on examinations and closed.
We did, okay,
sorry.
Yeah, we just need to do the minutes. So do we have a motion on the minutes? Any second? Do we have any discussion? All in favor? Any opposed? Any abstaining? So we pretty much covered everything, right? Right?
Yes.
Anything further? Okay, we have a motion. Do we have a second?
Second.
Any discussion? All in favor? Any opposed? Any abstaining? Thank you.
Does anyone want to share a lift to Burbank?